We have a decent amount of participants logged on, so I'm gonna get us started here for our webinar. The first thing I'd like to do is say good afternoon and welcome everybody who's joining us, including our panel that I'll say a bit more about in a moment, and also all the different listeners that have logged on. My name is Jonathan Butler. I'm the president and CEO of One Berkshire, and this afternoon I'll be your moderator. I'd like to remind everybody that this session is being recorded, and it's also being simulcast live on Pittsfield Community Television, and we're expected to have about 100 plus live listeners for this webinar. So many of us in recent months have been focused on COVID-19 and responding to a lot of the workplace changes as a result. But today we're actually kind of excited to take a break from that and have an important discussion about the Paid Family and Medical Leave Act in Massachusetts, which is about to get fully underway. I know as an organization representing many businesses in our region, we've been fielding a lot of questions, and it's been a hot topic in terms of inquiries and with HR offices seeking some guidance. So I think that's our primary audience today. So with that, I'd like to first introduce kind of our panel of experts. I'll be moderating this conversation and then trying to get out of the way and let these folks talk about what's happening with the Paid Family Medical Leave Act. But first introduction is we have with us Bill Alpine, the director of the Department of Family and Medical Leave. Bill was appointed in 2019. He previously served as a corporate counsel for a nationwide environmental consulting company. And before that, he was the executive director of the Commonwealth's Petroleum Product Cleanup Fund, where he was responsible for developing the day-to-day administrative functions of the Commonwealth's environmental claims program. So Bill, I know you've joined us recently as well, but thank you for coming on today.
Thanks, Jonathan.
We also have another familiar face, Kevin Kinney, who often joins us for these types of HR trainings and these, whether it's a One Berkshire virtual town hall or some type of a webinar format like this. Kevin is a partner at Cohen, Kinne, Valicenti and Cook. After practicing for several years at one of Boston's largest law firms, Kevin returned home to the Berkshires in 1994, which we appreciate. He has 2 decades worth of experience representing business and individual clients, and his work in state and federal courts and his cases have been profiled in national and international legal publications and newspapers. So Kevin, thank you as well for joining us.
Thanks, Jonathan. Thanks for having me.
And we also have with us Patti D'Amaddio, the Director of Strategic HR Services for the Employers Association of the Northeast. Patti has 15 years of experience in corporate HR and over a decade of experience at the Employers Association. And she served for over 10 years as an HR executive for a $600 million division of a nationally based IT and engineering firm. So we're very pleased to have you with us today, Patti.
Thank you. Happy to be here.
And just thematically, so our listeners are aware, we try to be intentional about the types of expertise that we're able to bring into these panels. So you're very well served with the government perspective coming from Bill, the legal perspective coming from Kevin, and the HR perspective coming from Patti this afternoon. So I think the first thing we'll just move into is kind of this conversation about what is the Massachusetts Paid Family and Medical Leave Act. And I know that from the perspective of each of you, there's some important points that you want to make in terms of the what that we're discussing today. But we thought it was important to just do a real brief refresher for everybody listening, just on the time frame that we've gone through for paid family and medical leave. So I'm just going to run through a few different dates and milestones that have been reached and remind everybody kind of the path that we're on. On June 28, 2018, Governor Baker signed into law an act relative to minimum wage, paid family medical leave, and the sales tax. And that's really when this process started. In September of 2019, notice to workforce of contribution rates and leave benefits was signed. In October of 2019, payroll withholdings actually began. In December of 2019, private plan exemptions became due. In January of 2020, contributions themselves became due. And in January 2021, which is what we're going to be talking about a little bit as we look to a couple months ahead of us, employees and contractors are going to be able to start using parts of the program. A couple significant pieces are accessing up to 12 weeks of paid family leave for birth, adoption, or foster care, up to 20 weeks of paid family medical leave for individuals' own serious health conditions, and up to 26 weeks of paid family leave to care for a covered service member. And then it's in July of 2021 where the remaining piece goes into effect, where up to 12 weeks of paid family medical leave can be used for family members' health conditions. So those are just kind of the dates and the timeline that we followed. But maybe Bill can start us off a little bit on the what, and then you can each just sort of chime in with some of your thoughts on what exactly we're heading into in the next couple of months.
Yeah, sure. Thanks, Jonathan. There's a couple of key things that may not necessarily be obvious based on the timeline. We opened up our call center on September 9th. So anybody that has a question regarding the program can now ask those questions through our call center, which is being maintained by a private vendor. We're also in the process of fulfilling and developing the claims administration process, and there's going to be an online portal for employees and employers, and there's going to be correspondence that's taking place between the two through those portals. But probably most notably, while we have a January 1st deadline to start accepting claims and approving claims, we're actually going to do a soft launch on December 2nd, where we're going to accept bonding claims for those individuals that have had a child within the last 12 months or are anticipating a birth during 2021. And we're going to be starting up that process, as I said, on December 2nd. It's going to give us kind of a learning experience, how we can test our systems, but also more to alleviate a high volume of claims that we anticipate getting from bonding. If we're anything like Washington State, when they opened up live on January 1st, we're going to see a lot of bonding claims. We're anticipating, just guesstimating, around 13,000 in the first couple of months. So that's the filler I want to offer, Jonathan.
Great. And I also, at this time, thanks for that, Bill. I want to just remind everybody that's listening, I should have done this at the beginning, that we will have a Q&A component following this panel discussion. And you can submit questions either through the chat function in the bottom of the webinar or through the Q&A function. So please feel free, as questions pop into your head, to submit those. And what we'll do is we'll go through and we'll try to choose some of the questions that'll answer, speak to the critical mass. So thank you. Kevin or Patty?
Jonathan, I just wanted to jump in to add a few things to what you said in the beginning about the background on the new act. I primarily represent employers, and I think some of the things that I have wanted my clients to know, and that I hope that the folks on the webinar understand, is that there are some pretty stiff penalties here that employees have the right to pursue a private right of action if they feel that they've been that their rights have not been enforced properly under the statute. There's a 3-year statute of limitations for employees to bring claims, and the court can not only award reinstatement for an employee if there's been a violation of the statute, but there can be a treble damage award for lost wages and attorney's fees, along with civil penalties for failure to comply. The other big thing that I am hoping employers take from this webinar is that there are anti-retaliation provisions, which those of you who have been paying attention to the statute, I'm sure, are aware, but any adverse action taken against an employee within the first 6 months of an employee taking leave under the statute is considered presumptively retaliatory. What does that mean for you as an employer? That means that you need clear and convincing evidence in order to demonstrate that if you, for example, terminate an employee who's been on leave under the statute, or there's been some sort of negative change in their employment that isn't trivial, then it can be considered presumptively retaliatory and a violation of the statute. So that's important for employers to know, that it's really crucial to document your performance issues with your employees to demonstrate that it's not a retaliatory conduct if you decide to take action. A couple of other quick summary type things is that as Bill and his team have been working on changes to the regulations. There's been a change in the last couple of months about substance abuse disorders. Family and medical leave can be taken for treatment of a substance abuse disorder that either the employee has or potentially a covered family member who's receiving treatment for a substance abuse disorder may qualify for leave under the statute. And Bill, I'd love to have a little bit more of an explanation from you about your views on intermittent leave, but that's a big issue. And also former employees, if they've been separated for less than 26 weeks from you as an employer, and they're currently unemployed, not working for another employer after you, then the former employee who otherwise qualifies for paid family and medical leave may be able to apply for benefits through you as the former employer. So Bill, before we talk to Patti, I was wondering if you would just give a little bit of insight into the intermittent leave provision that you guys have in the updated regulations.
Yeah, intermittent leave was something that has been a challenge throughout the process. We modified the definition a bit with this last set of regulations, and if I didn't mention it, we modified our regulations, revised them this July. We came out with our first set last July, but as we were doing outreach like this, we realized there was some questions that came up that we needed to clarify. So we came out with those regulations. One of those areas was intermittent leave. We've stated in there that it will only be paid by us within in increments of 15 minutes, and not until the employee attains 8 hours of leave through the intermittent leave process will we accept a claim. We've also placed in there that the minimum leave increment must be consistent with the employer's established minimum. That certainly is from an administration standpoint and an adjudication standpoint, certainly a challenge, but that's something that we're placing the obligation on the employee and the employer to follow. So we're still working things out, and despite the fact that we have an adjudication system, it's going to be going through many revisions even after we launch on January 1st.
The final thing I wanted to say about the updated regulations, which I thought were very helpful. In fact, the very first interaction that I had with Bill came back in March before he and I knew each other through these webinars. I called his office and he was very responsive about the issue of a covered contract worker. And, the new regulations clarify the issue that I had at that time, which is that up until the updated regulations went into effect, it wasn't clear who would actually be considered a covered contract worker. But now, if you perform services as essentially an independent contractor under Massachusetts law, and you're properly classified as that, then you're not considered part of the workforce for purposes of the paid family leave eligibility, which I think is an important distinction. And what employers have to be careful of, and what I would really urge you to focus on, is it's a difficult threshold to characterize someone as an independent contractor under separate Massachusetts law, including the wage laws. And so you should be careful about whether or not they actually are properly classified as an independent contractor. But if they meet the definition, then they are not considered a covered contract worker for purposes of the paid family leave.
That's great. Thank you, Kevin, and also Bill. Patti, was there something that you wanted to add from the HR vantage point on this first topic of what is paid family and medical leave?
No, I think Bill and Kevin have done a great job. I do want to reiterate what Kevin has said, is that this is, of the many things the employer needs to be doing right now, one of the most significant is to truly identify performance issues and not keep them covered up anymore, really start addressing those performance issues and manage the performance up, if at all possible. And if not, it may be time to separate, but have that documentation in order. I think the other thing, most of our members on this call probably have over 50 employees, but I'm certain there are some that do not. So it's important. This is a whole new ball game for them because they have not been administering or have not had to administer FMLA. So it's really a time for them to become familiar with FMLA and start to develop a policy that they are going to be able to follow and communicate with their employees. But I'll go through more of the items about what the employer should be doing in a few moments.
So that does put us into a perfect transition to the next our next slides and topic. But anything else that Bill or Kevin you wanted to add before we shift gears a little bit to the employer side?
No, from my perspective, that's a pretty good general overview.
Great. So yes, the in terms of what should our employers be doing, this has certainly been the question that we're getting at an organization like One Berkshire. I'm sure our peer organizations are hearing the same. So certainly there's a whole laundry list of different considerations here, from job descriptions to updating time off policies, alignment of FMLA and PFML, training and beyond. So maybe the best way to kind of jump into this is maybe from the perspective of employers, what they should be thinking about HR wise, legally. Maybe Kevin or Patty can kind of jump into that.
Great. I mean, Kevin, why don't I start with I do have an outline, and I'm very happy, as I said, Jonathan, earlier, to share this outline so you can distribute it to the participants. They don't have to scurry around writing notes. And we may not have time.
We'll absolutely do that, Patty.
Right. I think one of the things that I think is most important right now is that the employer identifies somebody on their staff, and I would suspect that's going to be an HR representative, who's learned about this law, to be the subject matter expert that's going to be able to actually accept responsibility for responding to the Department of Paid Family Leave when they send in an inquiry about this employee. Because the employer will have 5 days to respond, the employer really needs to be sure that they have someone in place that understands what the department's expectations are going to be of us, because they're fairly substantial. Making sure we can report the wages, making sure we have the job description, making sure we can articulate clearly what our paid time off policies are. That person is going to need to be able to quickly and efficiently respond to the department in a timely manner. And so I think having a subject matter expert is going to be really important. Kevin, do you want to add to that?
I couldn't agree more. I think really not just having a subject matter expert, but also conducting training, and this may be part of your outline, Patty, but conducting manager training on leave management. For example, how are the requests going to be handled? Who is going to be the point person at HR on handling the requests so that the managers know what to expect? And then they should know about the other applicable leave laws, which we can talk about in a second. But I couldn't agree with you more about having someone who's the...
The next item I had on my list, which you've got on the slide here, is really the first thing is updating those job descriptions. This is a monkey on our back. Job descriptions along with employee handbooks are probably the two nemesis of most HR professionals, but it's really going to be important that job description be accurate. And it include things like the scheduled hours, the days of the week, the hours of the day. Is it full-time? Is it part-time? What are the essential functions of the job? And include a comprehensive environmental and cognitive physical requirement assessment. So the department knows whether this person can or cannot perform the duties of their job and make some informed decisions. But those descriptions are going to be very, very important. And we tend to have them, we find quite frequently they're way out of date.
And Patty, those are, from my perspective, those are so important, not just for the paid family and medical leave or the FMLA, if that applies to these employers, but also for disability-related claims under the ADA or under Chapter 151
Right.
in Massachusetts, because if you don't have updated job descriptions and you have an employee who can't perform the essential functions of the job, at least as you know them, and you can't demonstrate what those real essential functions are, it's going to be hard to argue when the employee says, I need a reasonable accommodation, and you as the employer say, well, no matter what type of accommodation, you can't perform the essential functions. And if the employer has nothing to prove what those are, they run into trouble. Again, that's not really just related to the Paid Family and Medical Leave Act, but it's an important thing to keep in mind.
Right, right. And for those of you who look at the job descriptions and you may feel just totally inundated, there really are some great resources that you can tap into to start this project. If you haven't visited ONET, O-N-E-T, online.org, this is a website hosted by the Department of Labor. It has very good job descriptions on it. It's hard to write these from scratch, so don't reinvent the wheel. Look at ONET, see if any of those job descriptions can help kickstart your process. For those of you who are members of the Employers Association, on our website, we have a job description writer that could also be a really great tool for you. But don't go it alone. There are tools out there, but those descriptions and the essential function evaluation will be really important. And I'll send you a sample of that, Jonathan, as well. The next thing I had on my list, Kevin, is updating your time off policies. Employers will be able to hold their employees accountable for following our leave of absence policy steps and processes, and for following our time off policies, our call out procedures, our absence reporting, our attendance policies. They will have to follow those. So it's really important that they get clarified. You know, when you look at time off and call out, are you expecting them to speak to their supervisor directly? Can they text their call out? Must they call in and speak to a human being? What information do they need to provide in that call? Do they have to have an active number on our record that we can reach back to them that day? And what information are you expecting them to give you? Why are they out? How long are they going to be out? How do we reach them? When do you expect them to call? Before the shift, after the shift, within an hour of the shift? And what are the consequences if they don't call? But you want to button up those call out procedures. And again, to Kevin's point, train your managers so that manager A isn't saying, oh yeah, just give me a text. And manager B is saying, oh no, you've got to follow this strict protocol. That inconsistency between managers can really shoot us in the foot.
I think those are good pieces of advice, Patty. And one particular policy that I'd like to just focus on for a second, for those of you who have FMLA policies in effect already, is that please make your managers aware, and HR should obviously be aware, that the Paid Family and Medical Leave Act eligibility is not the same as the eligibility for FMLA. So it's considered the same as eligibility for unemployment. So it's not 12 months and 1,250 hours like FMLA is. And I think the biggest thing that I worry about for employers is the benefit year is different. In the FMLA, you've been able to have multiple choices of what type of benefit year for the 12-month of leave entitlement that you could have. But under the Paid Family and Medical Leave in Massachusetts, you can't measure that time period backwards. So you can't use the rolling look-back method. Here, under the Paid Family and Medical Leave, you have to measure the leave entitlement period over the 52 weeks starting from the Sunday immediately before the first day of that job-protected leave. So for example, if an employee is requesting paid family and medical leave, say on February 1 of 2021, they'd have their 12-month eligibility period measured from Sunday, January 31st until the following January 30th. And so when you're looking at your policies, like Patty's recommending, and I couldn't agree more, you want to make sure that you're thinking about whether you should align the methods of calculating that 12-month eligibility period if you otherwise have FMLA policy in place. Because it could be a real administrative inconsistency if you have one rolling period for purposes of FMLA and another for purposes of paid family and medical leave. I would recommend that you're consistent with them. And you know, most employers would probably prefer the 12-month look-back method, but since it's not an option for paid family and medical leave in Massachusetts, I think that may be more difficult to do. Bill, what was the thinking on that from your department about having it go forward only?
It's the statute that dictates that. However, we have by regulation, in effect, done a certain look back, with the exception of the first year, beginning on January 1st, 2021. As we know, all leave or any other leave program runs concurrently with the leave that's allotted by us. So if an employer or an employee takes leave through a plan or some type of offering from their employer, the benefit year begins when they commence that leave. And so what that means is if they come into us later on, we're going to look back to that. That's one of the major changes we did to the regulations. The benefit year begins on the date you first commence taking leave, whether it's with us or with some other program. And it's incumbent upon employers to notify their employees that that is the case, and that any leave that they use, whether it be through vacation time or sick time or a plan offered by the employer, that time runs concurrently with our time. And again, it's only after January 1st, 2021. We cannot deduct anything that was taken in 2020 because there's no job protection there, and we have to align with the job protection elements which begin on January 1st, 2021.
So your look back period that you're referring to is look back to the beginning of the leave that may not be paid family and medical leave. It may be a paid leave under the employer's policy, correct?
Right, but it's a qualifying reason under our regulations and statute, and therefore we will take that into consideration. So if somebody takes 12 weeks of bonding leave beginning January 1st with their employer of 2021, and then they decide to come into us in June of 2021, we're going to say, no, you've already used the 12 weeks of bonding leave. Your benefit year began when you commence leave with your employer because you have job protection under the statute for that leave that you've taken with your employer.
I think as Bill's point.
I think we lost Kevin. You know, Bill, that was a very significant change, and I think most employers have not quite grasped that, how significant that is, because employees may elect not to contact Department of Paid Family Leave, and they may choose to use their short-term disability under the employer's policy or their PTO, but they're still on a protected leave. So it's a very positive clarification in the regulations.
Well, I'm glad we did something positive, Patty. Thank you.
I think Kevin's back with us. If you wanted to jump, I don't know if he's connected yet.
Maybe not.
He might not be connected yet.
So one of my other bullets, as Kevin started already talking about, is this discussing the alignment of FMLA with PFMLA. And I agree with Kevin. The PFML formula is really a looking forward, which a lot of employers have done. Start with the date of leave commencement and go forward 12 months. So it's not going to be a tremendously onerous transition for them. And I think that they want to go into your, if you have an FMLA policy, it's going to be important you go into your policy and adjust that definition. And under the federal regulations, you have to give, I want to say, 30 or 60 days notice of changing your formula under FMLA. So we want to do that now, because so that people know that as of January 1, the 12-month period won't be a look back, it will be a look forward. So that, Kevin, are you with us now?
I think Kevin jumped off probably to try to reconnect with the new signal.
Okay. But I think we want to make sure we get that done for those people who are covered under FMLA. Get that notice out to employees now so that you have the November, December timeframe covered before January 1, and get those two years formulas aligned.
Thanks for picking that up for me, Patty. Sorry about that. I had a little technical difficulty.
And Kevin, for the life of me, I'm like drawing a blank. I know under FMLA, if you're going to change your calculating of the year formula, you have to give, is it 30 or 60 days?
It's 60 days. And
60 days, okay.
And you have a requirement to send out the notification. So if anybody has any questions about that, just feel free to contact One Berkshire, and Jonathan can reach out to me, and I'm happy to send along a sample of a notification.
Great, but I was saying that this is the time to do that, so they have November and December to get that 60-day notification met.
I agree.
Patty, we're doing a good job following your outlines. I'd say just keep going.
The next item I had on my list was training your managers, as Kevin mentioned earlier. They are so key, whether it's FMLA or SNLA or PFMLA. Do we need another acronym, guys? ADA. We need to, our managers are our eyes and ears of the HR department. And they know, they're the ones that have firsthand knowledge when people are absent and why they're absent. And that's not always information that floats back up to HR in a timely manner. Training your managers so they recognize what constitutes an eligible FMLA or PFMLA event. Who's going to be eligible? They don't have to work a year. You know, all of those criteria. How are we going to handle intermittent in our operation? You know, what is their role relative to administration of PFML, or do they just turn it over to HR? All of those components we need to train our managers on, because otherwise they are operating in the dark, and we don't want that.
One follow-up on policy that we were talking about before is that I think this is an opportunity for employers to consider adding a substance abuse policy or revising an existing policy because of the new inclusion of substance abuse into the Paid Family and Medical Leave Act. As I mentioned before, substance abuse disorders where there's treatment for substance abuse can be eligible for leave under the Paid Family and Medical Leave Act. So just focus on that policy. Also, you know, I'm a big believer in code of conduct policies or acceptable conduct policies where it's clear that if an employee violates the policy that they're subject to discipline up to and including immediate termination. And I like to have a list of the things that could be grounds for immediate termination. It certainly helps for unemployment claims. That you can point to that list and say, you know, the person did this particular violation and we have it clear in the policy, and so they aren't entitled to unemployment. But it's also good for any other type of claim that you're defending from a wrongful termination standpoint. So if you add abuse of the Paid Family and Medical Leave Act to the code of conduct policies or workplace rules, and I think that would be helpful. Just take a fresh look at how your policies integrate with the new act not only the paid family and medical leave and FMLA interaction, but also these other policies.
Yeah. You know, when I look at training managers, the other thought I had was we really need to make sure we have our leave of absence request forms pulled together and in order. And for those employers that have under 50 employees, this is a new venture for you. So you're going to want to have a well-defined leave of absence procedure. And you're probably going to want to develop a leave of absence request form. So you know who's going out on leave and when, so your managers are managing this consistently, and train your managers on the use of that form.
Great. Patty, are there more items still on your outline that you wanted to specifically? Well, you got a rhythm going now, and you're hitting all the key spots. So.
Again, I think we also want to take a look at our attendance policies. Do you have a point system? Do you have an absence attendance program that says if you're absent, 3 occasions, on the 4th you get a warning, on the 5th you get a suspension, and on the next you're gone? We need to look at those policies and make sure they comply, and that we are backing out the time people take for PFML because it is protected time. We want to make sure our managers understand that this protected time cannot be counted as points or an occurrence. If they're administering their attendance policies and disciplines autonomous from HR, it's very important they understand that they can't be counting this lost time under PFML as punishable lost time. So it's important that they understand that.
Excellent.
I don't want to read my list. Is 4 pages long, and I can send it out, but it covers exactly, most everything that the employer should do relative to training their managers, updating their policies, getting a leave of absence policy, updating your call-out policies. There's an awful lot of tweaking we have to do to our existing policies.
Bill, I was wondering if you could just help explain a little bit about the concurrent part of the leave as it relates to employers' existing leave policies. I think it would be helpful to explain that from your perspective. So I'm talking about an employer who has existing leave of absence policies where they have sick time for their employees that may not be equal to the amount of paid family and medical leave that's available to employees. Could you just explain how the two work together from your perspective?
Sure. I guess in very basic form, if they have a sick leave policy, or if they allow their employees to utilize sick time, then if an employee chooses to use that sick time for what would be considered a qualifying reason under our program, that time would run concurrently with any allotment that we would provide. When we revised our regulations this year, we said accrued paid leave, which we've defined as vacation, sick, personal, comp, any of that time that's used by an employee in connection with a qualifying reason will preclude the employee from receiving a benefit from us. So you cannot receive the two at the same time.
So what happens in a situation where an employee comes to the HR department and says, I want to go out on leave, I qualify under the paid family and medical leave, tell me what I should do. Should I use my sick leave, or should I use the state's leave program? What's your view?
Well, it's really up to the employee as to what they should do. An employer cannot compel in any way an employee to use their accrued paid leave. That's prohibited by the statute. If an employee chooses to use it on their own volition, that's different. But, that's really a decision of the employee.
So I'm wondering about it because I know a lot of the HR professionals on the webinar are probably faced with this, where employees rely on them for their advice and input. So an employee comes to them and says, you know, I know you're not telling me what to do, but what do you advise? What's your advice for them?
And it really comes down to personal preference. If they have enough sick time, let's just say, and that's paying them at 100%, and our benefit is not, and they want to use the sick time because it's more lucrative, then that's a decision within their right. If they are not so concerned about that and just want the time and they want to keep their sick time and their vacation for other purposes, then, you know, they come to us for the benefit. And again, the benefit is not always going to match up, and certainly not going to always match up with accrued paid leave that's offered to an employee.
And so an employee, let's say an employee uses their paid family and medical leave in full, and then they still have sick time available to them, and it hasn't run concurrently at that point. Is that right?
If the employee starts out with our leave?
Yes.
Then it comes down to what's the employer's policy is insofar as the number of weeks. I mean, if the employer can certainly, you know, offer more than, say, 12 weeks in the form of bonding, but that's really at that point where we've looked at it, and the employer should too, that the benefit year began when we commenced or when they commenced leave under our program.
But Kevin, when you look at that, what I think we're saying here is that the employee has the right to elect, do I want to use my PTO or go through the state? But either one, if it's a qualifying reason, if I'm running my claim through the state, the fact of the matter is when I'm done with my PFML, I still have available paid time off to take because I have a flat tire, or my kid has the sniffles, or I have to make a lawyer appointment. So they would have paid time off that would be available to them for use for non-PFML reasons or additional PFML reasons.
Right, exactly.
Bill, I'd love to have you talk about the other policies. So most companies are offering a commercial short-term disability policy, or the employee has purchased an Aflac or a Colonial, and it may be them paying for it, or it could be the employer paying for a short-term disability policy. My understanding is they can collect through PFML and through the private policy, but not to exceed their regular wage.
And I would love to talk about that, Patty. But before we get there, if you don't mind, I'd like to just expand on a few things that you've brought out as far as policies and what an employer should be doing to prepare. That's okay with the group.
Absolutely.
Let's not lose sight of the fact that last year at this time, we were going through an acknowledgement and poster process where you had to put the poster in your conspicuous workplace and let the employees know when they went to a break that there was this program called DFML. So continue to keep that in the back of your mind. There's also the acknowledgements when you're doing new hires. It's very important that you make sure that the employees or the new hires continue to acknowledge those, establish some type of signatory and dissemination process of those policies, whether they be electronic. I say that because within those policies and acknowledgement, there's obviously references to the contribution rate and the benefit amount. And as you all know, we came out with a directive last week where we stated that the contribution rate and the benefit amount will remain as is throughout calendar year 2021. So it's probably a good time to take that and share it with your employees so that they are in fact aware that the contribution rate is going to remain at 0.75% and the benefit amount is going to remain at $850. There's also, we've done noticing of the approximately 225,000 employers in the state where we've reached out to them through information that's been provided to us by the Department of Revenue through their Mass Tax Connect system, where we've reached out to administrators that are handling payroll for the purposes of saying to those individuals, you've been designated as a contact for purposes of payroll. However, if you are the designee for PFML purposes, we would like you to fill out this questionnaire, fill out this form, and if you're not, please inform us as to who the right party is. So it's imperative that employers hopefully are all aware of that and they continue to respond to those requests. A lot of these would have been sent through payroll providers. So if you haven't received one, we request that you reach out to your payroll provider to see who they've designated, because that's how and with whom we're going to be corresponding when claims come in. We're going to try to have a repository of all the employers and all their designated leave administrators, and that's who we're going to be asking questions of and informing that a claim has been provided by their employees. So it's a good time, as Patti mentioned, to reiterate the policies, tweak your policies, inform them that the leave runs concurrently, respond to our requests, I guess, is a key point that we have for employers, particularly when we're administering a claim. That's our program integrity aspect. When we're reviewing a claim, we want to know that this employee exists. We want to know that they are an employee of the employer or a former employee of the employer. And please respond, because that's our program integrity. It helps us to hopefully reduce fraud or any other concerns that come in connection with a request. Also, employers should be cognizant of the fact that, particularly small employers, this is job protection. Your employees get to go out on leave. And for small employers, certainly there's a backfilling situation. So it's probably something to remind. Unlike FMLA, two spouses can go out on the same leave at the same time that work for the same employer. So there's these little scenarios, more as a refresher. I think we kind of lose sight of the basics, and that's what I'm trying to attempt to do right now. Hey, Patti, you want to do any follow-up?
No, I think that was great. People are still very confused about the topping off bill.
Yeah.
And the use of that private policy. So just to clarify, if your employees elect to use their company provided paid time off under, Massachusetts paid sick leave or their earned vacation time, they cannot file, they will not get a benefit from the state.
That's correct. And the only situation where you're allowed to top off is when the employer provides some type of temporary disability plan or policy or some other type of plan for leave that's not comprised of accrued paid leave.
So an AFLAC, a Colonial, or a self-insured.
We're definitely confident that plans provided by employers where the employer owns the policy, you can use both up to your average weekly wage. If an employee purchases its own policy and it's not through their employer and it's something that the employee obviously leaves with, even if they're not with not with the employer, we're not seeing right now that we have any way to factor those into the process.
So they could, with an AFLAC and a Colonial, they are employee paid 100% via payroll deduction. but it's still a private policy. It's not a group policy.
Yeah, and my understanding is that the employee owns that. If the employee were to leave, they take it with them. Unlike
Yes.
the employer-sponsored plan, where as soon as employment ends, that coverage under that policy ends as well.
Right. How will you coordinate that? Will you will be asking the employer if they're receiving pay from a supplemental short-term or long-term policy?
We're going to be asking a bunch of questions in general. Are you receiving any form of accrued paid leave from your employer? Are you receiving or have you applied for unemployment? Are you receiving or have you applied for workers' comp? Those two, workers' comp and unemployment, serve to reduce our benefit dollar for dollar. As far as the temporary disability plans and the plans provided by the employer, we'll be asking about those. But as far as monitoring those, it may be more of a post-audit because we look at ourselves as being the primary payer. And we can't wait to see what the carrier pays or the plan pays.
Right.
We pay.
Right. So, and Bill, have you worked out yet the administrative process by which the employer can submit for reimbursement?
Not exactly. We've been concentrating on getting claims mainly in the door from employees, and the correspondence that comes through in request of an employer to provide further information in connection with the claim. There's the employer portal there. Whether or not we're going to be obtaining claims for reimbursement from employers through the employee portal or the employer portal, I think it's still to be determined. It'll likely be the employer portal. The process will, in essence, there's going to be a standard of review. Is there a plan that exists? Is it no more stringent than what we would allow? Is it paying for a qualifying reason? All of these things will have to be taken into consideration.
Bill, when you're talking about the portal, one of the things that occurred to me was you have the ability as an employer to apply for benefits on behalf of your individual employees, although the employee themselves is the one that, if the employer doesn't take that on, then it's on the employee, correct?
Right now, Kevin, we'll only take claims from employees. They can deal with a leave administrator, and that's why we're asking for that information. But as far as someone filing a claim on behalf of an employee right now, it's not there.
That's that's eventually going to come though?
Yeah, I'm optimistic it will. It's just probably for launch, not so.
So that's something in the future that employers should think about, whether that'll help them administer the claims. But as Bill said, right now that's not available. It has to come from the employee.
So conscious of time, there is one more just general topic I wanted to just run into, and then I think we should get some of the user submitted questions. But one of the common pings that we've gotten at One Berkshire from our members and area employers is, how does the general public or employees, how are they going to be reminded about PFML and this coming into effect, and what are the obligations of the employer between now and January?
I think Bill did a nice job a moment ago of reminding people that they need to have their notice up. They need to get all new employees that are hired the notice of PFML and their acknowledgement of the contribution, which I still think is funny, Bill. It's a contribution, it's a tax. Contributions are optional. Taxes are not, but they have to acknowledge that. I do think that it would be wise to have a policy in your handbook about it in the leave of absence, and perhaps give people a summary, on that notice. It tells them the website, it instructs them how to file. The website is terrific. And there's a lot of really good information for the employee if they want to go out there and start, educating themselves. I just don't think as an employer, we want to take on an enormous personal burden of educating people other than short of the notices in our leave policy.
Yep.
We would just ask that we're going to be doing a lot of outreach, obviously, over the next couple of months. You know, how we do it and how it's disseminated. It's you know, going to be as widespread as we can make it, but a lot of it will be geared towards employers being able to inform their workforce. We'll be doing a lot of emails through our website. So if you're not on our email list, please do so. And informing your employees that if they have questions that you can't answer, that they can call our call center. And I will give those numbers right now if you want, Jonathan, or we can hold it to the end.
Why don't you share them now? We can.
Okay. So
post.
our call center is 833-344-7365. 833-344-7365, and the hours of operation are 8 to 5. If employers have questions on exemptions or contributions, we still have a partnership with the Department of Revenue through their call center, and that phone number is 617-466-3950, and their hours are between 9 and 4.
Great. And people will have that information when we share this back with them, but we'll make sure that we share the numbers as well when we communicate with all of the participants in the webinar.
And it's mass.gov/DFML. That's our website. When you go to our website in the future, you will see a link to our portals. The links to the portals, we're still working out the name. But it's going to be something along the lines of masspfml.com or masspaidleave.com, so or gov. But it's going to be a little different, but you will be always able to access it through our website.
Great. So why don't we jump to a couple of these user submitted questions? We certainly have some time for that. The first one that's come up a couple of times is, and I'll throw this out there, maybe Bill can start and we can hear from Kevin and Patty, but how should employers handle 401k contributions and insurance deductions during the leave?
For purposes of the insurance, the employer needs to continue to maintain their portion of the health insurance while the employee is out on leave. We've pretty much just established that for purposes of the employee share, it really comes down to your policy. And I know we've received a lot of questions, you know, as to whether or not they can use accrued paid leave to pay for that. The answer is right now there's, you know, the way we've written the regs there's a preclusion to that. It's something that I'm going to be looking into a little more closely in the upcoming weeks to see if we can come out with something that might clarify that in that unique situation. But again, I have to go through a number of channels for review before that happens. As far as 401k, you're either receiving our benefit or you're not. And if you're receiving, you know, leave from the employer through accrued paid leave, nothing changes. If you're receiving our benefit, I don't, you know, especially where there's an employer match, there's nothing, these are our wages, so there's nothing being paid by the employer.
Yeah, so that there, again, like Bill said, if you're receiving wages from the employer, those wages can be subject to 401k or 403b contribution. But if it's not employer paid wages, then they're not going to be subject to that. And an insured policy like LTD, STD, those are issued by commercial carriers. They would not be subject to 401k or 403b contributions.
That was one of the things that I was referring to when I was talking about an HR person faced with an employee who comes to them and says, what do I do? That's another example of something that they should at least factor in to the analysis of what they want to take. And Bill, I'm interested to hear your take on, or if you could describe to everybody, you got a situation where an employee comes and says, I want to take paid family and medical leave. I want to know whether I continue to accrue vacation time while I'm on the leave.
And that, again, is something that's left to the discretion and to the policy of the employer.
So that's why I think it's really important that the vacation pay policy, because under Massachusetts law, vacation pay policies are a function of the employer has the choice. It's not mandated by law, but once you have a policy in effect, then you have to abide by it. So this may be a situation where looking at the vacation pay policy and saying vacation pay doesn't accrue when you're on paid family and medical leave is a good thing to do. And as Bill just said, it's not a requirement that it continues.
Right. And that is often left unsaid, Kevin, even prior to PFML, with FML or even a personal leave. A lot of employers' policies are silent on what will happen relative to paid holidays during leave, what will happen to paid vacation. Will it continue to accrue, and paid sick time, if it's an accrual versus a cliff earning? And those are very important policy provisions that should be clarified.
I agree.
There are some provisions in FMLA, if you are an FMLA obligated employer, that when a holiday is impacted, if it's a leave of greater than, I believe, 5 days, but not less than 5.
Another question that was submitted is, can an employee top off PFML benefits with paid sick time from an employer long-term sick bank? Anybody want to jump at that one?
Bill, I would say no. If I have not used all of my vacation, or I have not used all of my sick time that is accrued, and the employer has allowed me to roll it into a bank, it's still paid sick or vacation.
Yes, and we've put that in the regs. It's one of those things that falls within the definition of accrued paid leave. The difference is an extended sick leave bank is a form of allowing the employer to seek reimbursement. So if an employer pays an employee exclusively through that process, they can apply for benefits or reimbursement back to us, provided the employee has not received a benefit already from us and that they qualify with all other aspects of the regs.
Okay. Bill, this is a brief question. I think this is probably referencing the private plan exemption, but a listener asked, what percentage of mass employers have opted out at this point?
Around 4,000 out of what I believe to be 225,000 employers. So I don't have my calculator, but pretty small.
That's interesting. I do think the feedback I've gotten, Bill, is that people are concerned about the cost of reentry into the state plan. And I think you've done some really good work on that too, Bill.
Yes, and while we're at it, Patty, we're in the process of our renewal program right now. So we've concluded the renewal period for exemptions that were granted to employers that chose self-insured, and that was September 30th. There was only about 450 of those, and as of the data I received yesterday, about 400 of those renewed, and you know that's promising. We'll notice them one more time at least in case they didn't get the message. And you know the element there is that you have to have a bond that's issued to the benefit of the Commonwealth. There's also the private plan exemption process, which makes up the vast majority. I think that's around 3,400 employers. That deadline has been extended to December 31st because we have been working with the Division of Insurance, and they've come out with a template for the benefit of private carriers. However, each plan type that's particular to a carrier has to be independently reviewed by the DOI. So that's obviously created a little bit of a timeline, and hence the reason why we extended it to December 31st there. Key point in all of this is, if you decide right now, after already having an exemption, to back out and go back to the state plan, we will be coming back after you for contributions, plus interest, and possibly penalties. Penalties is really the only thing that I'm aware of that we can waive, but we will be working with DOR. So if you haven't renewed, we're going to notify you, and DOR is immediately going to send you a past due amount based on whatever withholdings they have in their system.
How's that going to work, Bill, with the employee contribution?
As far as,
if they're going to go back after the employer,
right,
then what's the employer do with respect to the employee contribution to this?
We've made it very clear in the regulations that they cannot go back after the employee.
So this is a real strong reason to get this right then.
I would agree with that, Kevin, yes. And believe me, it's a lot easier for us, for everybody to renew, because we certainly don't want to get into collection activities. And it's much easier if everybody renews beginning next year. And, you know, if you don't renew, but you've already been in the system, say 2 years, we will likely allow that transfer. If at that time you decide to come back to the state plan, we will let you back in, and the effective date of coverage will be the first day following the first day of the first month, quarter following the date of termination. I know the regulations say that there's recourse there, but I think we'll be re-exploring that and just make everybody even at that point.
Bill, forgive me, but could you repeat that? So in the first year, this year, if people have it exempted and they, on year 2, 2021, at the end of 2021, they want back in the plan, we're going to go back for a year and collect contributions?
If they back out now, we will go back to October 2019.
Okay. But if they back out or change direction in 2021 and want into the plan, the state plan,
we will, and again, the regulations don't read this way, we will likely consider that just a smooth transition. Again, I'm just speaking purely as an estimation here. It's not what's in the regs.
Any idea?
The regs would in essence allow us to go back.
Yeah. Had there been consideration of the employer having to pay runout claims, or?
Yeah, yeah, that's it. That's in the new regs. And we've said is that an employer under a private policy, the carrier or the employer owns any claims that were filed prior to the effective date of the termination. And the effective termination, the date of termination is the last day of the quarter. So they own anything, they own the run out of those claims, they own the liabilities of those claims, and then we take over.
Okay.
And vice versa.
Bill,
right.
Can you speak yet to the taxability of the benefit? Have we gotten any ruling on that?
I cannot speak to that, Patty. We have not received a ruling on that. We attempted to get some guidance from an RFP process where we requested bids from law firms. We put out an RFP. There's about 10 or 12 different questions we have, not only about contributions, whether they're taxable, whether they're imputed income, if an employer pays part of the contributions, as well as the benefits. We didn't get any bids. And
that says a lot, Bill.
So now I am on Plan B, and I'm working with the Department of Revenue to see what, if anything, we do with respect to withholdings. Right now, we're in a dilemma stage because we're developing our system software and our adjudication process, and that's not necessarily something that's out of the box and would require some configuration within our system. We may be just going to the level of saying to employees that apply for benefits that these may be taxable. What document we issue, 1099-G or something else, working with the Department of Revenue to see if we can try to figure that out. And we're not alone. The state of Washington is, also waiting a determination. But for some reason, I can't remember if it was Washington or some other state, I don't know, Connecticut, but somebody I was talking to the other day in one of those states said, yeah, we're equally awaiting a decision from the IRS. However, our statute allows us or gives us the coverage to not withhold until the IRS is ruled, which that would have been nice if we had the same.
Bill, one of the posts from an attendee was really helpful. I think everyone would want to know that the question is, you have health insurance that you're offering to an employee who's gone out on leave, and the employer is continuing to pay their contribution. Let's say it's 80-20. How the employer pays their share to the health insurer, and what happens with the employee share?
Yeah, that came up earlier. And we've basically taken the position that it's between the employer and the employee. And again, I realize that the accrued paid leave element here, don't know where that's going to go, but it's maybe something we will explore.
All right, I think at this point we're about 3:15. We've gotten through all of the participant submitted questions. Are there any other tidbits that any of you wanted to throw in, or any other questions related, to this whole topic that any of you wanted to hit on before we transition kind of closing up?
I don't think so. I do think there is one question here about, the Employers Association, we don't have a checklist of the advantages and disadvantages of opting in or going into the state plan or out of the state plan. I think that's, and this, I think, Jonathan, you could speak to. I think that's a decision that is going to be very client specific, based on how they tend to fund. Are they going to self-fund? Do they have the revenue and the reserves to self-fund? Are they going to privately insure? I think that's really case by case.
Yeah, I agree with Patti. I think it is a case-by-case situation. I don't think there's a real checklist. I don't have a checklist that I've used, but I think one thing that some of my clients have considered was using an outside administrator for that, and that could be a very helpful way to do it.
Mm-hmm. I would say, one of the advantages might be is that your employees are working with an agency or a commercial carrier that you have engaged. It keeps the administration just a little bit closer to the company. But if I think about our employers in Rhode Island who have been dealing with TDI for 20 or 30 years, they don't care. They don't want anything to do with it. They just administer their own leave policy. And if the employee wants to apply for TDI, that's between them and the state. And it's been a non-issue for Rhode Island for many years, right, Bill?
Yeah, Patti, I will not proclaim to know anything about Rhode Island. From the information I've been provided, I think things are fairly broad there. As far as coverage and allowance of other sources of wages. So,
yes.
Yeah, they're vastly different as far as I understand.
So, it depends on if you, there are so many of our members that are very paternalistic, and they really want to help facilitate a smooth payment process for their employees that may want to keep that private policy so that they can keep their hands in it and assist the employee when they're filing a claim, and troubleshoot issues when the claim is held up, and kind of be that paternal component. And it does keep some of the administration closer to you, as opposed when it's completely adjudicated by the state.
I would also say, from the perspective of One Berkshire and our members looking for guidance there, really employers large or small, it is really kind of a case-by-case analysis for each business to make. And I think we would encourage any businesses out there to speak with your legal counsel, or speak with your your insurance rep that helps you on the HR side, and make sure that you get the right information you need before making any of those decisions.
Right.
So I think it's a good time to probably wrap up. I'd love to just give each of you a minute or two if you want to share a closing thought or any other comments for the listeners. Also, feel free to use it as an opportunity to plug your own business or organization a little bit and the services you provide. Why don't we start off with Patti?
Well, I just want to thank you, Jonathan. One Berkshire has been a great partner for us for many years, and we really appreciate being able to join in today's discussion. I want to assure members, you've lived through COVID now. COVID has made PFML look like a cakewalk, I think. And I think we need to just feel like the sky's not falling. Half of our workforce is not going to go out on leave. I think we know who's going to try to take advantage of this. It's the same people that have historically tried to take advantage of FMLA or SNLA or any other policy we have. The bulk of your employees are amazing individuals, and they're not looking to take advantage. I would say, honestly, I've said it for the last year and a half, identify your performance problems and address those now.
Kevin, closing thought?
Again, thank you, Jonathan, for having us all on. It's been really helpful to hear Bill and Patti's perspectives on this, and I'm happy to answer any questions that anybody has offline. If you want to share my email address, people certainly can contact me. I'm always happy to talk about these issues. And I think one of the things that's helpful about this program that this is now my second PFML program with One Berkshire, and Bill was on the earlier one as well. And Bill, I really appreciate you taking the time to talk with everybody. You're virtually coming out to the Berkshires. We really appreciate that you're paying attention to us. We don't always get the attention from the state, and you've been incredibly responsive in my dealings with you, and it's just nice to know that we're getting that kind of support from the state. So thank you very much, Bill.
I would echo that sentiment.
Agreed. We've been well served, Bill, in terms of just the accessibility and availability that you've had as we've kind of all navigated this out here in the western side of the state. A final thought from you, Bill?
Yeah, no, great. This has been great. Thank you very much, Jonathan, and One Berkshire for allowing me to speak again. As Kevin put it, you hear my perspectives, and I would just like to preface that by saying, yes, some of these things are not final. They are my perspective, and certain things need to come into play. We're still learning a lot. There's still a lot of things that we have to provide guidance and opinion on. So just keep that in mind. It's a very fluid program. It's new, and it's going to continue to evolve and have changes throughout, and we're going to do our best to make the employer and the employee experience as beneficial and as happy as possible.
So with that, I'd like to just I'd like to thank our listeners for participating today. Certainly some good attendance. Hopefully this has been helpful. If there are any follow-up questions from any of you, please feel free to submit them to us at info@oneberkshire, and we'll get them into the right hands so you can get some additional guidance. And I remind you all again that you'll get a communication from us early next week sharing the recorded version of this webinar, some important information from Patti's team, and also some other contact information and follow up to this program. So also just one more thank you to this whole group of panelists. I think this was a very valuable experience for everybody that took the time to participate this afternoon. You're all excellent. You're experts in your area of work, and I know you're very busy people. So we really appreciate, from a One Berkshire perspective and the regional perspective, you taking the time to help us out with some of those questions today.
Our pleasure.
Thank you.
Thanks, Jonathan.
And with that, we head into Columbus Day weekend in the beautiful Berkshires. We got a couple of sunny days on the forecast, so hopefully people can get out and support some local businesses and do so safely. But enjoy the weekend, and everybody, be well. Take care.
Thank you.
Take care.